Okay, let's unpack this. We've got quite a stack of source material here, articles, legal analysis, some case notes, really digging into some complex legal stuff.
Yeah, RI2, vicarious liability.
Exactly, and how they can, kind of surprisingly, intersect with places like entertainment venues.
Mm-hmm.
So our mission in this deep dive is really to cut through the legal jargon, pull out the key insights for you, and understand the risks, maybe even that guilt by association idea people worry about.
And what's fascinating, I think, is seeing how the law, specifically RICO, that's the Racketeer Influenced and Corrupt Organizations Act, how it's evolved.
Right. It started with organized crime, didn't it? The mob.
Precisely. But
Yeah.
the law itself, it mandates a liberal construction. Basically, judges have to interpret it broadly.
So it's stretched beyond that.
Oh, definitely. Its reach now covers all sorts of things, from drug cartels, sure, but also white-collar financial schemes, you name it.
So, yeah, definitely not just gangsters anymore.
Not at all. And for the government to make a standard RIQ case stick, they have to lay out like 5 key things.
Okay.
First, there has to be a criminal enterprise, like an ongoing group, an organization. Second, they need to prove you had an association with that enterprise.
You were connected somehow.
Right. Third, that you actually participated in its activities. Fourth, and this is crucial, they have to show a pattern of illegal acts.
A pattern. What does that actually mean in practice? Is it just doing bad things twice?
It's a bit more than that. The sources talk about continuity plus relationship. So think of it as a series of connected illegal acts. Those are the predicate acts.
Yeah.
And they need to show these happened over a period of time, or that they showed a clear method, basically proving it was the enterprise's regular way of doing business, not just isolated incidents.
Right, right. Okay, so here's where it gets really interesting and maybe hits closer to home for you listening. Why entertainment venues? Clubs, bars, event spaces, why are they vulnerable?
Well, they often present, let's say, ideal conditions. Cash businesses, for one.
Like nightclubs or bars.
Exactly. They can be, relatively easy places for money laundering, mixing dirty cash with legitimate sales, maybe inflating revenues on paper.
Makes sense.
And sadly, sometimes venues like hotels or big event spaces can get tangled up in things like human trafficking investigations. Drug distribution, too, might happen right there, or be facilitated through parties or events linked to the venue.
And you mentioned history, like the old speakeasies.
Yeah, or illegal gambling dens, places that maybe bribed officials to look the other way. The venue itself was kind of enabling the crime.
And this isn't just dusty history, right? The sources gave current examples.
Absolutely. Cases like the Alamo nightclub, allegedly used by a cartel for trafficking weapons, drugs, or the recent RICO allegations surrounding Sean Diddy Combs' business empire connected to claims of abuse.
Right, that's been everywhere.
And of course, the Jeffrey Epstein case. It really highlighted how seemingly private social gatherings, elite circles, could become the alleged backdrop for a horrific sex trafficking operation.
And the fallout for people associated with him.
Exactly. Huge scrutiny on his associates, sometimes regardless of what they actually knew or did. It shows how legitimate-seeming settings can be tied, or alleged to be tied, to serious RICO activity.
Which brings us back to that guilt by association feeling. And the sources also brought up vicarious liability. How does that fit in? Is it the same thing?
It's related, but legally distinct. Vicarious liability is broader in a way. It means being held responsible for what someone else did because of a specific relationship you have.
Like employer-employee.
That's the classic example. Respond to its superior. The employer might be liable for an employee's wrongful act done on the job. You didn't do it, but the relationship makes you potentially responsible.
Okay, so how does that connect back to RICO and, the risks for someone just associated with a place or person? The sources mentioned distinguishing the RICO person from the RICO enterprise. That sounds important.
It is, especially for one specific part of RICO, Section 1962C. Generally, for that claim, the accused individual or company, the person, has to be legally separate from the criminal group, the enterprise.
So the company can't be both the villain and the tool simultaneously, sort of.
Sort of, yeah. You usually sue the person conducting the enterprise's affairs through racketeering, not the enterprise as the person, if that makes sense.
Okay.
But that distinction isn't always required for other parts of a RICO, or critically, for RICO conspiracy.
Conspiracy. Okay, that sounds broad.
Yeah.
And maybe a little scary.
It can be. Because with conspiracy, under Section 1962, the focus shifts. You don't necessarily have to have committed the underlying crimes yourself.
So what do you have to do?
Simply agreeing to the overall criminal goal of the enterprise can be enough. If you join the conspiracy, you can potentially be held liable for foreseeable crimes committed by your co-conspirators in furtherance of that plan. That's often called Pinkerton liability.
Wow. Okay, so that really explains the guilt by association worry. You might just be connected, maybe didn't directly do anything illegal, but if you agreed to the basic illegal plan, you could be on the hook legally, or at least reputationally.
Precisely. And reputationally is a huge factor now. Media, social media, they amplify everything instantly.
Yeah.
It creates this environment where association alone fuels intense public judgment, often way ahead of or even ignoring the legal facts. Think Epstein's associates again or Combs' Circle. The association itself became the story.
So legally speaking, what's the defense if you're just associated but didn't do anything?
Well, the core legal defense against a direct charge is showing you lacked criminal intent or knowledge, the mens rea. If you genuinely were ignorant of the illegal stuff happening, that's fundamental.
But then there's this thing called willful blindness, the
Yeah.
sources mentioned. Sounds like a counter to just saying, I didn't know.
I mean, it absolutely is.
Yeah.
Willful blindness is essentially deliberately avoiding knowledge. If the signs of wrongdoing were obvious, like big red flags waving, and you consciously chose to look the other way so you wouldn't know, the law might say that's as good as actually knowing.
Okay, that's tricky.
It is. And remember, for conspiracy, you don't need encyclopedic knowledge. You don't have to know every detail or every other person involved. Just agreeing to the basic illegal objective and knowing the general criminal nature of the enterprise is often enough.
It's quite striking reading the sources how these risks aren't just about, shady nightclubs. It's about navigating professional circles, digital communities. Vigilance applies across the board.
A lot of context.
So to kind of wrap up this deep dive, RICO and vicarious liability, they're complex, powerful legal concepts. They can reach into areas you might not expect, like entertainment venues. And for you, the listener, understanding association risks, especially with conspiracy and willful blindness, is pretty crucial, not just legally, but because of the massive reputational impact in today's world.
Absolutely. And from a defense perspective, it's about meticulously challenging every single element the prosecution needs to prove the enterprise, the pattern, the specific acts. And crucially, focusing on intent proving lack of knowledge while also being ready to fight any suggestion of willful blindness. It's about drawing a clear line legally between association and actual culpability.
Right. Separating the legal reality from the public perception.
Exactly. So maybe a final thought for you to chew on. In an age where who you know or where you go can be instantly broadcast and judged by millions, how does understanding these tangled legal ideas, RICO, conspiracy, association, change how you approach not just physical spaces, but your digital networks and your social circles too? Something to think about.
Racketeering, vicarious liability, and navigating entertainment venues. A legal analysis. 1. Introduction. The landscape of racketeering and liability. This report provides a comprehensive legal analysis of the Racketeer-Influenced and Corrupt Organizations (RICO) Act, the doctrine of vicarious liability, and their complex interplay, particularly as they relate to individuals attending or associated with entertainment venues connected to alleged criminal enterprises. The objective is to arm defense attorneys with robust arguments and viable points to challenge potential criminal and civil liabilities, as well as mitigate reputational damage, ensuring a rigorous defense against guilt by association. In an era of heightened public scrutiny and rapid information dissemination, individuals can face severe reputational and legal consequences based on perceived associations. This analysis underscores the fundamental principle that every American is entitled to a rigorous defense, emphasizing the distinction between public blameworthiness and legal culpability, and advocating for justice rooted in evidence and due process, not popular opinion. The intricate legal framework surrounding RICO and vicarious liability demands a meticulous approach to defense, particularly when public narratives can overshadow legal realities. 2. Understanding RICO. The Racketeer-Influenced and Corrupt Organizations Act. The RICO Act, codified as 18 U.S.C. Section 1960, 1000, 1968, was enacted as Title IX of the Organized Crime Control Act of 1970. Its primary purpose was to combat organized crime by preventing its financial infiltration into legitimate businesses operating in interstate commerce. This powerful federal statute was designed to strengthen legal tools for evidence gathering, establish new penal prohibitions, and provide enhanced sanctions and remedies for the unlawful activities of those engaged in organized crime. While initially aimed at dismantling traditional mob syndicates, RICO's broad statutory language and legislative intent for liberal construction have allowed its application to extend significantly beyond its original scope. This adaptability has enabled prosecutors to target white-collar criminals, financial operators, and corporate entities. This expansive applicability is a critical aspect for defense, as it means many non-traditional, organized crime scenarios can fall under RICO's purview. The deliberate choice by Congress to draft RICO with broad definitions created a versatile legal instrument. This broadness, while empowering prosecutors to dismantle complex criminal networks, simultaneously presents a significant challenge for defense. It means that seemingly legitimate business activities or associations can be swept under RICO's umbrella if a pattern of racketeering activity is established. For defense attorneys, this necessitates a strategic approach that goes beyond merely disproving direct criminal intent. It requires challenging the very definition of the alleged enterprise, the relatedness and continuity of the alleged acts, and the nexus to interstate commerce, even in cases that do not fit the traditional mob boss stereotype. The mandate for liberal construction means courts are often inclined to find a RICO violation if the technical elements are met, placing a higher burden on the defense to meticulously dissect and challenge each component of the prosecution's case. To prove a RICO violation under Section 1962C, the government must establish 5 core elements beyond a reasonable doubt. 1. Existing cull entity, or any group of individuals associated, in fact. This definition is considered not very demanding. The enterprise must be engaged in, or its activities must affect, interstate or foreign commerce. 2. Association with the enterprise. The defendant must have been employed by or associated with the enterprise. 3. Participation in conduct of enterprise affairs. The defendant must have conducted or participated, directly or indirectly, in the conduct of the enterprise's affairs. This requires having some part in directing the enterprise's affairs, participating in its operational management, and not merely performing services for it. 4. Pattern of racketeering activity. This requires at least 2 acts of racketeering activity, predicate acts, within a 10-year period. The predicate acts must demonstrate continuity plus relationship. They are related if they have similar purposes, results, participants, victims, or methods. Continuity can be a long-term association for criminal purposes or a regular way of conducting an ongoing legitimate business. 5. Commission of predicate acts. The participation in the enterprise's affairs must be through a pattern of racketeering activity, meaning the defendant committed at least 2 predicate acts. Table 1. Common RICO predicate acts, 18 U.S.C., Section 1960, 1. Category. Examples of predicate acts. Federal crimes, mail fraud, wire fraud, bankruptcy fraud, securities fraud, drug-related offenses, illegal gambling, extortionate credit transactions, counterfeiting, embezzlement from pension, welfare funds, witness tampering, money laundering, sexual exploitation of children, interstate transportation of stolen property, state crimes, punishable by 1 year imprisonment, murder, kidnapping, gambling, arson, robbery, bribery, extortion, dealing in obscene matter, dealing in narcotic, dangerous drugs. This table is crucial for defense attorneys, as it provides a quick reference to the specific criminal acts that can form the basis of a RICO charge. Understanding the breadth and specificity of these predicate acts is the first step in identifying potential vulnerabilities in a prosecution's case, as each predicate act must be proven independently. It helps in assessing whether the alleged conduct truly falls within the statutory definition of racketeering activity for RICO purposes, which is a foundational requirement for any prosecution. Table 2. Elements of a RICO violation. 18 U.S.C. Section 1960. 2. Element. Description. 1. Existence of an enterprise. Any individual, partnership, corporation, association, or other legal entity, or any group of individuals associated, in fact, must engage in or affect interstate, foreign commerce. 2. Association with the enterprise. The defendant was employed by or associated with the enterprise. 3. Participation in conduct of enterprise affairs. The defendant conducted or participated, directly or indirectly, in the operation or management of the enterprise's affairs. 4. Pattern of racketeering activity. At least 2 predicate acts within a 10-year period, demonstrating continuity plus relationship, relatedness by purpose, results, participants, victims, or methods. Continuity by long-term association or regular business conduct. 5. Commission of predicate acts. The defendant's participation in the enterprise's affairs was through the commission of at least 2 predicate acts. This table provides a clear, concise checklist of the elements the prosecution must prove beyond a reasonable doubt for a substantive RICO charge. For defense attorneys, it immediately highlights the points of attack. If any single element cannot be proven, the RICO charge fails. It serves as a foundational reference for constructing defense arguments, ensuring no critical component of the prosecution's burden is overlooked. RICO violations can lead to severe criminal and civil penalties. Criminal convictions can result in fines up to 25, 0, and 20 years in prison per racketeering count, or even life imprisonment if a predicate offense involves murder. A crucial aspect of criminal RICO is the mandatory forfeiture of all ill-gotten gains and any interest in businesses acquired through racketeering activity. The threat of pretrial asset seizure further complicates defense efforts by potentially limiting resources for legal representation. In addition to criminal provisions, RICO allows private individuals damaged in his business or property by a racketeer to file a civil suit. Civil RICO actions operate under a lower burden of proof preponderance of evidence compared to the criminal standard of beyond a reasonable doubt. Successful civil plaintiffs can recover treble damages, which means triple the actual damages sustained. A recent Supreme Court ruling in medical marijuana, Inc. v. Horn significantly broadened the scope of civil RICO, clarifying that it can provide a remedy for business and property loss that derives from a personal injury. This means that conduct previously leading only to state law claims, such as fraudulent representations about products causing personal injury and subsequent business loss, e.g., lost wages, could now trigger civil RICO liability and treble damages. It is important to note that no criminal RICO indictment or civil complaint can be filed without prior approval from the Criminal Division of the Department of Justice. The policy emphasizes selective and uniform use, indicating that not every proposed RICO charge meeting technical requirements will be approved, as the primary responsibility for enforcing state laws rests with the states. This rigorous internal approval process underscores that a RICO charge is a significant federal undertaking, reflecting a deliberate decision by prosecutors to pursue complex, long-term criminal conduct rather than isolated incidents. 3. RICO's infiltration of entertainment venues. Organized crime and racketeering enterprises exploit entertainment venues due to their inherent characteristics, often leveraging them for a range of illicit activities. These venues provide a facade of legitimacy, a steady flow of cash, and opportunities for discrete interactions, making them ideal for criminal operations. One primary mechanism is money laundering. Cash-intensive businesses like nightclubs, bars, and casinos are particularly vulnerable. Criminal organizations can inflate daily sales reports to intermingle dirty illicit cash, often derived from drug trafficking or other predicate acts, with legitimate earnings. This cleaned money is then deposited into bank accounts, making its origin appear legitimate. Gambling operations, including slot machines, referred to as pokies in some contexts, are also used to launder money by depositing large sums and cashing out smaller, seemingly legitimate winnings. Human trafficking is another grave crime facilitated by entertainment and hospitality venues. Hotels, motels, and other hospitality establishments are common locations for human trafficking due to ease of access for buyers, the ability to pay in cash, and the privacy and anonymity they offer. Traffickers exploit automated check-ins, third-party reservation systems, and non-mandatory identification to maintain secrecy. Beyond hotels, trafficking also occurs at sporting events, theme parks, and cruise ships, highlighting the pervasive nature of this exploitation within the broader tourism and entertainment industries. Entertainment venues can also serve as discrete hubs for drug distribution networks. The high volume of patrons and the often lax oversight in certain establishments create an environment conducive to illicit transactions. Furthermore, social media platforms, increasingly intertwined with the entertainment industry, have become major venues for drug sales, making illicit drugs easily accessible, particularly to minors. This digital dimension expands the reach of drug distribution networks far beyond physical venues. Historically, extortion and illegal gambling, alcohol sales were foundational to organized crime's involvement in entertainment. Mafia families controlled numerous bars and clubs, operating them as disorderly houses or private bottle clubs to circumvent liquor licensing laws. This involved bribing law enforcement, serving watered-down or stolen alcohol, and engaging in extortion by blackmailing wealthy patrons with threats of outing their sexuality. These practices demonstrate how seemingly legitimate venues can be deeply embedded in racketeering activities. Beyond these, venues can also facilitate firearms trafficking, creating and selling counterfeit goods, and cybercrime, further diversifying the illicit revenue streams. Illustrative case examples underscore these mechanisms. The Stonewall Inn, historical. During the 1960s, the Genovese crime family owned and operated many gay bars in Greenwich Village, including the Stonewall Inn. They ran it as a bottle club to avoid liquor licenses, bribed police, reportedly, $200 a month to the 6th Police Precinct, and engaged in extortion by blackmailing wealthy patrons who wished to keep their sexuality private. The club also reportedly served watered-down or stolen alcohol in dirty glasses due to a lack of running water, contributing to a hepatitis outbreak. This historical example vividly demonstrates how a venue, ostensibly for entertainment, was systematically exploited for multiple racketeering activities, highlighting the deep infiltration of organized crime into seemingly legitimate businesses. The Alamo nightclub, contemporary, a recent Immigration and Customs Enforcement (ICE) operation in Charleston, South Carolina, resulted in over 70 arrests at the Alamo, an underground illegal nightclub run by a suspected member of the Los Zetas cartel. This club was a documented location for weapons, narcotics, and human trafficking, with authorities seizing cash, drugs, and firearms during the operation. This case illustrates the continued and sophisticated use of entertainment venues for high-level transnational organized crime, demonstrating how illicit activities are integrated into the operation of such establishments. Sean Diddy Combs and Bad Boy Entertainment. Sean Combs has faced RICO allegations related to his record label, Bad Boy Entertainment, for alleged drug trafficking and violent crimes. More recently, he has pleaded not guilty to running his business empire as a racketeering enterprise that enabled and concealed the abuse of women over 2 decades. This case highlights RICO's potential to reach into the entertainment industry and target high-profile figures, even when the enterprise is ostensibly legitimate. The ongoing trial has opened a window into the hip-hop industry and the music industry at large, drawing significant media and public attention to the alleged activities and their broader implications for his associates. Jeffrey Epstein's social gatherings. While not a traditional entertainment venue in the commercial sense, Jeffrey Epstein's properties and the events he organized served as a nexus for his alleged international sex trafficking ring. His status as a socialite and financier allowed him to operate within elite circles, drawing prominent individuals to his orbit. The subsequent revelations and legal proceedings have brought intense public scrutiny upon those who associated with him, regardless of their direct involvement in his criminal activities. This situation exemplifies how association with a criminal enterprise, even through social gatherings rather than commercial transactions, can lead to severe reputational damage and legal challenges for those perceived to be connected. The case has also highlighted a 2-tiered system of criminal justice, where the powerful may receive preferential treatment, further fueling public discourse and scrutiny of those in their social network. 4. Vicarious liability. Imputing responsibility. Vicarious liability, also known as imputed liability, is a legal principle where one party is held responsible for the actionable conduct of another, even if they were not directly at fault. This concept is founded on the doctrine of respondeat superior, which asserts that an employer can be liable for the negligent acts of employees performed within the scope of their employment. It is a form of strict liability because the principal is considered to be in control of the agent, and the agent's actions are seen as representing the principal. No direct wrongdoing on the part of the managing individual or entity is needed for a finding of vicarious liability. For vicarious liability to apply, key conditions generally include whether the subordinate's actions were related to their job duties, intended to benefit the employer, and executed during work hours and in a work-sanctioned environment. The superior must also have either actual or apparent agency in their ability to stop or rectify the damaging behavior. Common applications of vicarious liability extend across various legal contexts. Employee liability. The most common form, where an employer is held liable for an employee's misconduct if the injury was foreseeable and the employee was acting within the scope of employment. This includes workplace harassment or discrimination. Parental liability. Parents may be held accountable for their children's harmful actions, particularly if they entrusted the child with a dangerous instrument. Product liability. Manufacturers, wholesalers, and retailers can be held strictly liable for injuries caused by defective products regardless of fault in the manufacturing process. Alcohol vendors and social hosts. Under dram shop laws, alcohol vendors or social hosts can be liable for harm caused by an intoxicated person they served. Civil conspiracy claims. All parties involved in a conspiracy to commit a harmful act can bear liability for the civil and criminal consequences, even if they did not personally commit the act that caused the harm. Business partners. Certain partners, like unlimited partners, can be liable for another partner's misconduct if it occurred in furtherance of the partnership's business. The application of vicarious liability within the RICO context presents unique complexities and has been a subject of legal debate. Proponents argue that holding employers liable for the racketeering acts of their employees advances congressional intent, as RICO was enacted to protect individuals and companies from corrupt enterprises. Conversely, opponents contend that it is unfair to penalize an employer for the actions of its employees, especially when RICO's primary intent was to protect businesses from infiltration by racketeers. A critical aspect of vicarious liability under RICO, particularly for claims brought under 18 U.S.C. Section 1962c, is the RICO person v. RICO enterprise distinction. This principle dictates that the RICO person, the defendant, cannot be the same entity as the RICO enterprise. They must be distinct. Most circuits in the United States have held that a RICO plaintiff cannot use theories of vicarious liability or respondeat superior to circumvent this requirement for Section 1962C claims. For example, if a plaintiff names a corporation as both a RICO defendant and the enterprise, most circuits will dismiss the RICO claim for failing this distinction, even if a vicarious liability component is present. This interpretation aims to prevent the wrongful imposition of liability on enterprises that are themselves engaged in racketeering, preserving RICO's intent to target those who profit from such activities rather than victimize legitimate businesses. However, this strict distinction is not uniformly applied across all RICO subsections. For claims under Section 1962, a prohibiting investment of racketeering income in an enterprise, and Section 1962b, prohibiting acquisition, maintenance of an enterprise through racketeering, courts have shown more willingness to impute vicarious liability to an employer. This typically occurs when the employer was an active perpetrator or central figure in the scheme, or, more generally, when the agents committed racketeering activity that directly benefited the corporation. If the employer is found to be a victim of the racketeering conduct, they may not be held liable. For RICO conspiracy charges under Section 1962d, the scope of liability is notably broad. Anyone who agrees or conspires to pursue the same criminal objective can be held liable for a RICO violation. This means that if conspirators have a plan where some commit the crime and others provide support, the supporters are considered as guilty as the perpetrators. A conspirator need only intend to further an endeavor that, if completed, would satisfy all elements of a civil RICO claim. This is often referred to as Pinkerton liability, where a member of a conspiracy can be held vicariously liable for the crimes of their co-conspirators if those crimes were foreseeable and committed to further the conspiracy's objective. While this liability is considered personal rather than strictly vicarious, as it requires a shared conspiratorial intent, it significantly broadens the scope of responsibility within a criminal network. 5. Attending events connected to RICOs, blameworthiness, and reputational ruin. Association with individuals or entities accused of RICO violations, particularly those operating within entertainment venues, can lead to severe blameworthiness and reputational ruin, even without direct involvement in criminal acts. This phenomenon, often termed guilt by association, is amplified by the rapid dissemination of information through digital channels and the sensationalization of crime by media outlets. Modern media, encompassing social media, mainstream news, and entertainment, profoundly shapes public perceptions of crime. The overrepresentation and sensationalization of criminal activity can create a skewed public view, fostering fear and influencing opinions about individuals associated with alleged criminal enterprises. This can lead to a post-truth prosecution environment, where public opinion is swayed by headlines and social media narratives, rather than by the meticulous standards of legal due process. The public's fear of crime, which is currently at a 3-decade high, can lead to avoidance of crowded events in central city areas, further contributing to a climate of suspicion around venues perceived as unsafe or linked to illicit activities. The broader societal impacts of organized crime, such as socio-cultural disintegration, corruption, and economic monopoly, indirectly affect those associated with such groups. Illicit trade, often facilitated by organized crime, fuels corruption, drives demand for forced labor, and undermines legitimate economies, creating a pervasive negative social environment that can tarnish anyone perceived to be connected. The cases of Jeffrey Epstein and Sean Combs serve as stark, illustrative examples of how attendance at events or association with individuals connected to alleged RICO enterprises can lead to profound reputational damage. Jeffrey Epstein. Epstein's status as a socialite and financier allowed him to cultivate connections within elite circles, providing a veneer of legitimacy for his alleged international sex trafficking ring. Individuals who attended events organized by him or frequented his properties, even if unaware of his criminal activities, have faced intense public scrutiny and reputational fallout following the revelations of his crimes. The public discourse surrounding Epstein's case has highlighted a perceived two-tiered system of criminal justice, where the powerful may receive preferential treatment, intensifying the backlash against anyone associated with him, regardless of their direct culpability. This demonstrates how proximity to a high-profile criminal enterprise can be devastating for one's public image. Sean Diddy Combs. Sean Combs is currently facing RICO allegations related to his business empire, including claims of sex trafficking and racketeering. The ongoing trial has opened a window into the hip-hop industry and the music industry, drawing significant media and public attention to his alleged activities and the individuals within his orbit. Even those not directly charged but merely associated with Combs or his events have experienced public condemnation and reputational harm, illustrating the broad reach of public blameworthiness when a high-profile figure is implicated in a RICO enterprise. For defense attorneys, mitigating reputational damage is a critical component alongside legal defense. While direct legal culpability requires proving specific elements, public perception operates on different criteria. Strategies may involve proactive communication, emphasizing a lack of knowledge or intent, and, where appropriate, clearly distancing the individual from the alleged criminal enterprise or its illicit activities. The challenge lies in navigating the complex interplay between legal facts and public narratives, where accusations can quickly morph into perceived truths, regardless of evidentiary support. 6. Differentiating liability. Ignorance versus awareness, participation. The potential for legal liability and reputational harm for individuals attending entertainment venues connected to RICO enterprises hinges significantly on their level of knowledge and participation in the illicit activities. A rigorous defense must meticulously differentiate between mere presence, ignorance, and active involvement. Ignorance of the RICO enterprise or activities. A key defense against direct RICO charges is the lack of culpable intent or knowledge, mens rea dop. If an individual genuinely lacked knowledge of the enterprise's criminal nature or its specific illicit activities, this can serve as a strong defense. For instance, arguments can be made that the alleged acts were isolated incidents, that the defendant was not truly associated with a criminal enterprise, or that they did not knowingly act with the intent to participate in criminal activity. Proving innocent intent directly counters the prosecution's assertion of criminal involvement, and a robust defense can present evidence of legitimate business practices or character witnesses to highlight good faith efforts. However, the legal doctrine of willful blindness can substitute for actual knowledge. This doctrine applies when a defendant purposefully avoids learning the specifics of illegal activities, despite being aware of a high possibility of wrongdoing. It is a deliberate attempt to keep one's head in the sand when faced with information that creates suspicion. A finding of willful blindness can establish the mental culpability required for a conviction, effectively negating the defense that the defendant lacked the required intent or was unaware of committing the crime. For defense attorneys, countering this imputation is critical, as prosecutors may argue that a person should have known, given the circumstances surrounding the entertainment venue or associated individuals. In the context of RICO conspiracy, the prosecution's burden regarding knowledge is notably less stringent. The government does not need to prove that the defendant agreed with every other conspirator, knew all of the other conspirators, or had full knowledge of all the details of the conspiracy. Instead, it must be shown that the defendant agreed to commit the substantive racketeering offense by agreeing to participate in 2 racketeering acts, knew the general status of the conspiracy, and knew the conspiracy extended beyond their individual role. This means an individual could be liable for conspiracy even if they were not fully aware of the entire scope of the criminal enterprise, as long as they agreed to participate in its broader objective through specific racketeering acts. Awareness or participation in the RICO enterprise. Individuals who knowingly participate in the operation or management of a RICO enterprise through a pattern of racketeering activity face direct criminal and civil liability. This direct involvement, whether through a formal position or by knowingly implementing the enterprise's decisions and being indispensable to its goals, establishes culpability under RICO. Furthermore, even if they did not personally commit the predicate acts, individuals can face conspiracy liability if they agree to participate in the enterprise's criminal objective. This is a powerful tool for prosecutors to reach those who direct or support criminal activity without direct involvement in every single illicit act. Co-conspirators can be held liable for foreseeable crimes committed by others in furtherance of the conspiracy, a principle known as Pinkerton liability. This expands the scope of responsibility within a criminal network, ensuring that those who facilitate or enable the enterprise's objectives are held accountable. For defense attorneys, a comprehensive strategy against RICO charges involves meticulously challenging each element of the prosecution's case. This includes disputing the actual existence of an enterprise, arguing the absence of a pattern of criminal activity, and, crucially, demonstrating that the defendant lacked the requisite knowledge or intent to participate in criminal activity. In cases where awareness or participation is alleged, defense may focus on the nuances of the operation or management test for direct liability, or the specific scope of agreement for conspiracy charges. Additionally, exploring plea bargaining or immunity agreements can be a strategic option to mitigate severe consequences. 7. Recommendations for navigating entertainment venues and related contexts. Navigating entertainment venues in an increasingly complex environment, where illicit activities can be covertly conducted, requires a proactive approach to personal safety and an understanding of potential indirect associations. General safety and awareness at physical venues. Attending large entertainment events carries inherent risks, including crowd-related injuries due to poor planning, such as overcrowding, blocked exits, and lack of trained staff. To mitigate these risks, individuals should engage in pre-event planning, review the event layout if a map is available, identifying exits, first aid stations, and open spaces. Wear comfortable clothing and shoes with good traction, and avoid long, loose items or large bags that can hinder movement. Ensure your phone is fully charged and carry a portable charger for emergencies. If attending in a group, choose a clear meeting spot in case of separation. During the event, vigilance is paramount. Remain attuned to your surroundings and observe any unusual congregation of people, especially near entrances or exits. If something feels off, like shoving, shouting, or harassment, move away from the crowd quickly and calmly. Stay near exits or less populated areas if convenient, and avoid standing beside rigid barriers. Prioritize hydration and rest, particularly in hot or confined environments. Limit alcohol consumption and avoid illegal substances to maintain awareness and judgment. Report any suspicious activity to event staff or security personnel immediately. Be aware of red flags, densely populated areas with limited movement, blocked or under designated exits, absence of clear security, or active crowd aggression. In case of a crowd surge, try to keep your feet on the ground. Push with the crowd towards the edge, and protect your chest by putting your arms in front of you. If knocked down, curl into a ball to protect your head and vital organs. Opting for VR and AR entertainment. Virtual reality, VR, and augmented reality, AR, offer compelling alternatives to physical entertainment venues, potentially reducing exposure to real-world risks associated with large crowds or illicit activities. However, these immersive technologies introduce their own set of unique safety and privacy considerations. Benefits for safety. VR and AR can provide entertainment experiences without the physical risks of crowded spaces, potential for violence, or direct interaction with individuals involved in illicit activities. New risks and mitigation. Data privacy. VR and AR devices collect sensitive data, including biometric data, eye movements, voice patterns, spatial data, room layouts, and behavioral data, user interactions. A data breach could lead to identity theft, stalking, or unauthorized tracking. Mitigation involves implementing clear terms and conditions, transparent privacy policies, and opt-in, opt-out choices for data collection. Developers should prioritize data minimization, collecting only essential data, anonymization, and secure storage, transmission using encryption. Blackmail and harassment. The burgeoning VR adult content market, for instance, creates opportunities for sextortion by cybercriminals who may claim to possess embarrassing evidence. Mitigation includes refraining from clicking suspicious ads and avoiding disclosure of sensitive personal data within VR, AR environments, unless absolutely necessary. Physical safety. Users can collide with real-world objects, experience discomfort, or even trigger seizures due to light flashes. Mitigation requires developers to implement boundary detection systems, like the Guardian system, provide safe virtual spaces, and offer settings to adjust experience intensity. Users should clear a safe physical play area, take regular breaks, 10-15 minutes for every 30 minutes of play, and consult a doctor if they have pre-existing medical conditions. Cybersecurity. VR and AR platforms are vulnerable to malware, social engineering, and intellectual property theft. Mitigation strategies include strong data encryption, multi-factor authentication, MFA, regular security assessments, user training on risks, and collaboration with vendors to ensure product security. Entertainment venues as they relate to religious organizations. Religious organizations, while serving vital community functions, can also be susceptible to financial crime and security risks, particularly when managing event spaces. Vulnerability to illicit activities. Churches and other religious institutions are vulnerable to financial crime, often termed ecclesiastical crime. This susceptibility stems from accounting record reporting loopholes, e.g., exemptions from IRS, Form 990, exploitation of the inherent trust among members, and a lack of robust internal controls or understanding of financial management. Unregulated donation environments allow illicit funds to be mixed with legitimate offerings, and criminals may even cleanse money by loaning it for construction work and receiving legitimate checks in return. The absence of Know Your Customer, KYC standards for congregants further increases this risk. Security risks in event management. Places of worship face various security risks during events, including theft, vandalism, internal threats from staff or volunteers, and crowd control issues. Active shooter incidents, though rare, also pose a significant threat. Ethical and legal considerations. Religious organizations are increasingly urged to divest from companies that exploit children, recognizing their responsibility to avoid complicity through investments or purchases. Many religious institutions explicitly prohibit the use of alcohol and illicit drugs on their property, as well as any behavior that could tarnish their moral standing. This reflects a growing awareness of their role in preventing illicit activities within their spaces. Mitigation for religious organizations. To combat these vulnerabilities, religious organizations should implement thorough background checks for all employees and volunteers, establish clear financial protocols for handling money and valuables, and monitor staff behavior for red flags. For events, hiring professional security teams, planning for crowd control, barriers, emergency exits, traffic flow, and implementing robust communication systems are crucial. Additionally, requiring signed facilities use agreements, FUAs, For external groups using church property, reviewing contracts annually, and ensuring external groups have liability insurance are vital legal protections. Proactive due diligence and transparency in financial dealings are essential steps toward exposing and preventing illegal funds from passing through religious institutions. 8. Conclusion and recommendations for defense attorneys. The landscape of racketeering and vicarious liability, particularly as it intersects with entertainment venues, is complex and fraught with potential legal and reputational pitfalls. The Racketeer Influenced and Corrupt Organizations (RICO Act), designed with broad applicability, serves as a potent tool for prosecutors, extending its reach far beyond traditional organized crime to encompass various forms of white-collar and corporate illicit activity. This expansive scope means that individuals, even those with seemingly tangential connections to an alleged criminal enterprise, can face severe consequences. Vicarious liability further complicates this landscape, imputing responsibility based on relationships and control, even in the absence of direct fault. While the RICO person, the RICO enterprise, distinction offers some protection under Section 1960 2C, other subsections, and the broad nature of conspiracy charges can still expose individuals to liability for the actions of others within a criminal network. The cases of Jeffrey Epstein and Sean Combs vividly illustrate how association with high-profile individuals implicated in racketeering can lead to profound public blameworthiness and reputational ruin, often amplified by media narratives that outpace legal due process. For defense attorneys, navigating these multifaceted challenges requires a rigorous and multifaceted defense strategy. The following recommendations are critical. Meticulous dissection of RICO elements. Every single element of a RICO charge the existence of an enterprise, the defendant's association, participation in its affairs, and the pattern of racketeering activity must be meticulously challenged. If any element cannot be proven beyond a reasonable doubt, the RICO charge fails. This requires a deep understanding of the legal definitions and the specific facts of the case. Aggressive challenge to pattern and continuity. The pattern of racketeering activity is the cornerstone of a RICO case. Defense attorneys should scrutinize the alleged predicate acts to determine if they truly demonstrate the required continuity plus relationship. Arguments can be developed to show that acts are isolated incidents rather than part of a cohesive, ongoing criminal enterprise. Disproving knowledge or intent, and countering willful blindness. A primary defense against direct RICO charges is the lack of culpable intent or knowledge. Defense must present evidence demonstrating the defendant's genuine unawareness of the illicit nature of the enterprise or its activities. Crucially, defense must actively counter any prosecutorial attempts to apply the willful blindness doctrine, demonstrating that the defendant did not intentionally avoid knowledge despite suspicious circumstances. Strategic analysis of the person-enterprise distinction. In cases involving Section 1960 2C, defense attorneys must rigorously enforce the RICO person v. RICO enterprise distinction, arguing for dismissal if the defendant and the alleged enterprise are not legally distinct. Understanding the nuances of how this distinction applies across different RICO subsections is paramount. Challenging conspiracy allegations. For RICO conspiracy charges, defense must focus on disproving the defendant's agreement to participate in the enterprise's criminal objective. While full knowledge of all co-conspirators or details is not required, demonstrating a lack of agreement to commit specific racketeering acts or a lack of awareness of the conspiracy's general status can be effective. Proactive reputation management. Given the pervasive influence of media and social perception, defense attorneys should advise clients on strategies to manage public image alongside legal defense. This may involve carefully crafted public statements, emphasizing a commitment to justice and, where appropriate, clearly delineating the client's limited knowledge or non-participation in alleged illicit activities. The goal is to separate public blameworthiness from legal culpability, exploring constitutional protections and alternative resolutions. Defense counsel should explore all available constitutional protections, such as First Amendment rights or challenges to evidence obtained through illegal means. Additionally, strategic plea bargaining or immunity agreements should be considered as viable options to mitigate severe penalties, especially in complex cases with multiple co-conspirators. By rigorously applying these defense strategies, legal counsel can ensure that individuals facing RICO allegations receive a thorough and equitable defense, upholding the principle that every American is entitled to justice based on evidence and due process, not mere association or public sentiment.